Let's examine the evolution of the federal system. Evolution is a slow and continuous change, often from the simple to the complex. The federal system established by the Constitution has evolved from a simple system of dual federalism to a complex system of intergovernmental relations characterized by conflicted federalism. Evolution has occurred in the power relationship between the national government and the state governments and their local governments, and the national government and local governments. However, our focus here is on the evolution of the dual sovereignty established by the U.S. federal system of government. We first survey four types of federalism, characterized by four different power relationships between the national and state governments, all of which continue to this day. We then explore various means by which the national government has altered the power relationship between it and the state governments. So the first one is dual federalism. It's also known as layer cake federalism because if you think about layer cake, gluten-free of course, there are different layers and you can tell the difference between the layers. So that is the distinct responsibilities between the federal, national, and local governments. Excuse me, national, state, and local governments. Initially, the dual sovereignty of the U.S. federal system was implemented in such a way that the national and state governments acted independently of each other. Political scientists give the name dual federalism or layer cake federalism to this pattern of implementation of the federal system, whereby the national government takes care of its enumerated powers and the states independently take care of their reserved powers. From 1789 through 1932, dual federalism was the dominant pattern of national-state relations. Congress and presidents did enact some laws that states argued infringed on their powers, and the courts typically found in favor of the states in those cases. Yet, as the 1819 McCulloch case shows, sometimes the court ruled in favor of the national government. All right, moving from dual federalism to cooperative federalism, otherwise known as marble cake federalism. And as you notice, there's difference. They're weaving in and out. You can't tell necessarily where one ends and one starts. A crippling economic depression that reached global proportions, known as the Great Depression, began in 1929. To help state governments deal with the domestic problems spawned by the economic collapse, Congress and President FDR approved numerous policies, collectively called the New Deal. Through those policies, the independent actions of national and state governments to fulfill their respective responsibilities evolved into cooperative efforts. Grants and aid, transfers of money from one level of government to another that need not be paid back, also known as intergovernmental transfer. Make sure that you know that those two are synonymous. That's grants and aid and intergovernmental transfers, became a main mechanism of President Roosevelt's New Deal programs. The national grants of money offered to the state governments and eventually also to local governments during the Great Depression had few specific terms and conditions. State and local governments welcomed the national grants, which assisted them in addressing the domestic matters that fell within the sovereignty, while allowing them to make most of the specific program decisions to implement the policy. The era of federalism that began during the Depression, with its growing number of collaborative intergovernmental efforts to address domestic matters reserved to the states, is the period of cooperative or marble cake federalism. Next, we have centralized federalism. By the time of Lyndon Johnson's presidency, a new kind of federalism was replacing cooperative federalism. In this new form of federalism, the national government imposed its own policy preferences on state and local governments. Specifically, in centralized federalism, directives in national legislation, including grant and aid programs with ever-increasing conditions or strings attached to the money, forced state and local governments to implement a particular national policy. Presidents since Richard Nixon have fought against the centralizing tendency by proposing to return policy responsibilities, policy making, policy financing, and policy implementation to state and local governments. Presidents Nixon and Ronald Reagan gave the name New Federalism to their efforts to revert such obligations to state and local governments, and today we use the term devolution to refer to the return of policy responsibilities to state and local governments. And if you think about it, both Republican presidents both wanted to make the government smaller. Today, Republicans and Democrats, including presidents, members of Congress, and state and local lawmakers, broadly support devolution, but they debate which elements of the policy-making process should be devolved: policy creation, financing, or implementation. They also butt heads over which policies to devolve. The legislation and court decisions that result from these debates make for a complicated coexistence of dual federalism, cooperative federalism, and centralized federalism, which leads us to the next one, and that is conflicted federalism. Scholars of federalism and intergovernmental relations use the term conflicted federalism to describe today's national-state governmental relations, which involve the conflicting elements of dual, cooperative, and centralized federalisms. Efforts to centralize policymaking at the national level are evident, as are efforts to decentralize the implementation of national policies to the state and local levels. For some policy matters, the national and state governments operate independently of each other, and hence dual federalism is at work. For most policies, however, intergovernmental efforts are the norm. These efforts may be voluntary and a means to advance state policy priorities, cooperative federalism, or they may be compelled by national legislation, centralized federalism. The era of conflicted federalism has seen an increase in the number of legal challenges to the national legislation that mandates state and local action. In the various cases that the Supreme Court has heard, the justices have ruled inconsistently, sometimes upholding or even expanding state sovereignty, and at other times protecting or expanding national sovereignty. For example, in 1976, the Supreme Court ruled in National League of Cities versus Usury that state and local governments were not legally required to comply with the national minimum wage law, hence protecting state authority. Then, 9 years later, in the Garcia versus San Antonio Transportation Authority 1985 case, the court ruled that the national minimum wage laws did apply to state and local government employees, thus expanding national authority. You don't necessarily have to know those two cases, you just have to know the example. Another policy matter that has been subject to conflicting court decisions is the medical use of marijuana. California has fought an up-and-down battle with the national government over medical uses of marijuana. In 1996, California voters approved the Compassionate Use Act, allowing people to grow, obtain, or smoke marijuana for medical needs with a doctor's recommendation. Then in 2001, the U.S. Supreme Court ruled that the national government could charge people who distributed marijuana for medical use with a crime, even in California where the state law allowed such activity. The court interpreted the National Supremacy Clause to mean that national narcotics laws took precedence over California's laws, which California had argued was grounded in the reserved powers of the states. But in 2003, the court refused to review a case challenging the California law allowing doctors to recommend marijuana to use to their patients. As a consequence of the court's refusal to take on the case, the decision from the lower court prevailed. The lower court's ruling had been that doctors could not be charged with a crime for recommending marijuana to patients. To add to the confused legal status of medical marijuana in California, the U.S. Supreme Court in 2005 upheld the right of the national government to prosecute people who smoke the drug at the recommendation of their doctors, as well as those who grow it for medical purposes. The confusion caused by conflicting state and national laws, as well as court decisions regarding medical marijuana, has become even more problematic since October of 2009, when President Obama's Attorney General announced that the federal government will not prosecute individuals who are dispensing marijuana or who are using it in compliance with state law in one of the states that has legalized such activities. Then, in 2011, federal attorneys raided and seized property from California medical marijuana growers and dispensaries. How did the U.S. federal system evolve from dual federalism to today's conflicted and quite confusing federalism? We'll look at that later.